And if you are removing a child, a contrary to the welfare finding in that order is mandatory.
Right.
If you do not make that finding whenever you remove a child from a placement, you're forfeiting federal funds. You can get away with it under state law. It'll catch up later. Things will get fixed. But my recollection is that the federal government says if you didn't make that right at the outset, first time through, you're not going to get any federal money for those services ever. And especially in the private removals, I mean, CPS will have its documents set up so that you're making those when you're signing off on it. On the private removals, grandma trying to take the kid, even if all the allegations are true, parents are horrible, those kinds of things, if you don't go through and check some boxes or make a finding somewhere in those original orders, CPS is going to have a kid that they can't pay for.
And let me tell you, we just had this happen in Maricopa County. We've had, at Durango, I told you they have all of the cases going through one judicial officer initially for signing all these temporary orders. A petition was filed by DES, and they did an in-home petition. And they thought they had good cause for making this an in-home. So the child was not removed from the home that the child had been placed in. By the way, this was a 15-year-old mother who herself was a ward and was in a foster care situation, okay? But when that paperwork is filed with the in-home petition, CPS, when we say CPS and DES, we're talking the same thing, all right? Child Protective Services, Department of Economic Security. They are represented by the AG's office, and you guys have told me today already that with the petition, they send over their temporary orders. In those temporary orders, they are designed for the in-home or the out-of. The judicial officer who read the petition thought, no way in-home, crossed off in-home, wrote out-of-home. But that, contrary to the Welfare Act finding, was not made. CPS is obligated, pursuant to that court order, to go in and remove the child. And right now, we're doing some backpedaling to set aside those orders so that that funding can attach to that baby and that. So anyways, if you are going to play with the paperwork that they're sending over for you because you think this child's at risk, make sure you have your staff call the AG's office and get out-of-home temporary orders put together so that you are making all the right findings or orders. Or if in doubt, call one of us and we'll walk you through it.
What happens, the question is, when a majority of the removal team under 8-822 doesn't agree with the removal? Is the remedy to dismiss the dependency, those kinds of things?
CPS is refusing to return the children.
Yeah. And my answer is no. And the reason is that there are two ways to remove a child. CPS can go in and grab them. They've got to be able to do that or people get hurt. The second way is upon order of the court, children can be removed. And I don't think you can say in good faith, well, it looks like CPS messed up, and so I am forced as a judge to return a child to an abusive situation where someone is going to get hurt. My answer is, well, that's too bad. There's must be some remedy in the law. Maybe it's a civil rights lawsuit or something for money if you want to pursue it. But once I've determined as a judge that this child should be removed, the answer isn't you messed it up previously and so we're sending the kid back. The answer is, okay, you're unfit. You go get a jury trial in civil land and convince them you're entitled to a bunch of money when the child should have been removed anyway. I would not return that child if, having gotten everyone in front of me, I determined that the child should be removed. I just wouldn't do it.